Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC. This is our bi-weekly call at immigration.com every other Thursday, and you would have heard the disclaimers as you entered. This call is subject to all those disclaimers. I'm going to get started, but let me make sure you guys can hear me okay. People are still logging in. Just make sure that you can hear me. Just a second.
The conference is now in conversation mode.
Can you guys hear me okay? Hello?
Yep.
Okay, good.
Yeah, we can.
Good. Thank you. Okay.
The conference is now in presentation mode.
I had asked the team to start cutting off the questions around 11 or 12 questions, because otherwise it becomes very difficult to finish the questions properly and to perhaps make time for a few new questions. And I think today we'll have time for new questions because they did cut it off, I think, at 11 questions. So let me begin by the question number 2, which is from Sita. She wants to apply for her parents' green card. She's a US citizen, and she or he, Sita can be a guy's first name also, I guess. So because of the Trump executive order, it was her concern, can I apply for her green card while she's still in India? And the answer is absolutely yes. To the best of my knowledge, we have never stopped applying. The ban, which is going to go away this month, is only in the entry, not in the application. So as far as I know, there should be no problem. We've been making applications for everyone. *5 if you have a follow-up question, Sita. Press *5 if you have a follow-up question. Okay, let's move along to the next question. This one is a little bit more complicated. So, filed for employment-based I-485 in February of 2012. That was a long time back. Hours were reduced from 40 to 32 in July of this year and was furloughed in October 12th. So a couple of months ago, I got furloughed. I might even get laid off in the beginning of next year. I have received my green card on November 10th, 2020. First of all, congratulations. That's good news. I'm not sure what this means. I have received my employment-based green card on November 10th. Oh, I see. That's the next line. From 2004 to 2020, I was working with the same employer, and they also gave me the supplement J. Should I have informed USCIS that my hours were reduced? No, absolutely not. You have no such obligation. Because you have an EAD, you can work any number of hours as long as the job was intended to be a permanent full-time job. See, when you filed your I-485 in February 2012, you were working full-time. In fact, you continued working full-time for 8 full years. I don't anticipate even a little bit of a problem for you. And if the government wants to create a problem, well, that's why the good Lord made courts. We'll take them to court. I am not concerned about it. You have no obligation to inform them about the reduced hours. I may not be able to work with company who provided I-485 supplement J because of furlough. Will this create an issue with naturalization? I do not anticipate so. Because, you see, you provide your supplement J in September 2019. After that, you still worked full-time hours, and then something came about which was beyond your control. Just keep track of your pay stubs. Keep track, don't lose a copy of your supplement J. Make sure that from September 2019 to the date of the furlough and reduction of hours, your time is your pay stubs are in hand. Scan them, put them on the cloud, keep them forever. I don't think you're going to have any problem at all. Can you apply for unemployment benefits? Absolutely. What happens is unemployment benefits are available because that's a private insurance. So basically, it's an insurance paid for by the private companies. So in other words, it's like getting life insurance benefits. I don't see any problem with getting unemployment benefits. Okay? *5 if you have a follow-up question. *5. Press *5 if you have a follow-up question. Okay. Let's go on to the next one. Misdemeanor. Well, first of all, remember one thing, guys. Whenever there is a conviction, a misdemeanor can be misleading. I have had situations where, I think it was in Arizona, if I remember correctly, I've asked for an opinion and they said, it's just a misdemeanor. I said, well, I don't like to give opinions without looking at the statute. And I look at the statute and it was actually a felony which they called misdemeanor class A or something like that. So first of all, whether it is misdemeanor or felony, somebody should take a look at the statute. And who should that somebody be? If you are in the United States, always seek an opinion. Of course, we can do it, but it's so much more money and time and money for us. It's probably better for you to go to a lawyer who does deportation defense in the state in which the crime occurred, where you were prosecuted. So let's say you live in Pennsylvania and you were driving through California and you'd had a drink or two and you got stopped, you got pulled over, and they thought your blood alcohol level was above the acceptable limit, and they basically convicted you. Or even if they discharged the case after a while, you should always get an opinion from a deportation lawyer in California, the courts where you were prosecuted. So that said, as a matter of context, now let's look at, I had a small incident recently. Another thing, remember the definition of conviction for immigration law can be very different than the definition of conviction under criminal law. I had a case many years ago, I think 4 or 5 years ago, where somebody was convicted of insurance fraud in Pennsylvania. It was a corporate insurance fraud case. And their lawyer assured me, oh, this is just a diversion program. This is not considered to be a conviction. And again, I being who I am, I said, I want to take a look at the statute. So the criminal defense counsel sent me a copy of the statute. And lo and behold, as I read through the statute, it said that when you take diversion, it means you have accepted the elements of the crime. In other words, you've accepted that you did it. Under immigration law, that would be considered a conviction, even though it may not be under Pennsylvania law. So conviction can be complicated. Whether or not it's a misdemeanor can be complicated. The third thing that is important to remember is expungement doesn't mean anything. Under immigration law, even if you have been convicted, you still have to reveal that you had a crime. Okay? So keep this thing in mind. So even if your charges, etc., are removed, you should get an opinion from a lawyer in your state where the crime occurred. I have an elder brother who's an Indian citizen, works in the Middle East. He's a civil engineer. I want to get a tourist visa. Will the above incident impact him? No, it won't, because it has no implication on his case. That his brother was convicted or tried for a misdemeanor is not imputable to him. I don't see any problem with it. I'm unemployed. Can I provide with an employer letter? What do you mean an employer letter? Well, first of all, for a tourist visa, there really is no set documents that must be provided in each case. Typically, just go online. he should file his DS-160 or whatever that application is called. Get that done. They will schedule an interview. They can ask for any documents they want, but he doesn't need an affidavit of support. He doesn't even need a letter of invitation. It is enough that his brother is living in USA and he wants to go visit. All those things can be asked for. It's okay to carry them, but I'm not aware of any standard documentation. At least we've never tabulated such a thing. I would say that go to the consulate website where you're applying. Make sure whatever their local rules are, and consulates can have local variations, whatever their local rules are, you are following those and go in. Be prepared if they ask you for more documentation to submit it later, but there is no standard documentation that I can think of that your brother needs to carry up front. Okay. Any advice if he applies from the Middle East? Well, if he lives in the Middle East, works in the Middle East, I don't see any problem with that. He can apply from there. Okay. *5 if you have a follow-up question. *5, Samir, if you have a follow-up question. Okay. Next one, question number 5. And this is from Mani Shankar. This is an H1 visa and spouse's H4 EAD expire at the same time, extension options. So one of the issues raised in this case was, if she applies for her H4 EAD and there is the I-485 EAD, can she keep both? And I'm not sure exactly what the protocol these days is, but the last protocol that I remember looking into during this time, or during this particular for this particular issue, was that if I already had an EAD approval and I got a second one, they would ask me which one do you want to keep. So I had to make a choice between one or the other. Nowadays it might have changed because the rights and benefits associated with employment authorizations are different for different types of EADs. So if you have a CPT employment authorization, it is different. If you have OPT first year, it is different. If you have OPT STEM extension, it is different. If you have H4 EAD, it is different. I-485 EAD, it is different. Most advantageous is the I-485 EAD. So if you are given a choice, ask to keep the I-485 EAD. Forget about the H4 EAD. But if they let you keep both, I would just use the I-485 EAD. That's the one I like the best. Let's look at the questions. I'm on H1B, priority date is EB2. My wife is on H4, working on H4 EAD. Company sent application to USCIS for 485, 765, 131. My H1 is expiring in 2021 June. Her H4 etc. is also expiring. How long does the I-485 EAD approval take? Nobody knows, because we just don't have enough data for these COVID times. Previously, it used to take 6 to 9 months. And before that, they used to have a 90-day deadline. They removed that. Now they don't have any deadline. So pre-COVID days, 6 to 9 months. Now I don't know how long will they take. Once she gets I-485 EAD, is it okay to start working? Absolutely. Does that impact my H1B status? No. Your wife's use of her EAD does not impact your H1. On January 20, my company is ready to file H1 extension. Is it okay to apply? Yes, absolutely. Even while the 485 is pending, you can apply for another H4, H4 EAD, etc. Along with your H1. And I already told you, if you got an offer to have one of them withdrawn, you can withdraw the H4 one. But if they let you keep both EADs, just use the 485 EAD. Wife's company is also ready to apply for H1B. I actually like that, because that way get her EAD under 485 approved, get her H1B approved, let her work on H1B. I think it is more advantageous, gives you more options. *5 if you have a follow-up question. Mani, press *5 if you are here. Okay. So this is area code 203. 203, where are you calling from?
Actually, I am in St. Louis, Missouri.
Acha. Okay, sir. How can I help you? Have a follow-up question?
So the only concern is my wife's company is ready to file H1,
Mhm.
and she already had previously used her 3 years H1, which finished in 2016.
Mhm.
But so I think since she finished in 2016, she can have another 6 year, and she can. So basically,
No,
by
no, no, no,
switching
no, no,
when
no, 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 no,
apply.
no, 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 stop. She does not have another 6 years. She'll have 3 more years.
But to apply H1, I know she has only 3 years left. But to apply again for renewal, right?
Mhm.
She can be applied till 2022.
Right. So the law says that if you have had an H1B approval within the last 6 years, you are not subject to the quota.
Okay.
Okay.
Yeah, so I think she will be not in the quota, right?
Right.
If
She won't be.
in 2021.
Right.
Yeah.
Right. Okay.
Yeah. So now, what her immigration team from her company is saying, the only concern they have, since she has a degree from India, and we get so for her, she got first approval in 2013.
Money. Wait.
Yeah.
Let me make it simple for you. Okay.
Okay.
If she applies for an H1 premium processing right away, you will know very quickly where it's gonna go. You still have time to file H4 EAD.
Got it. Okay.
So why get into this professorial debate about theory of this and theory of that? Let's find a practical solution. Practical solution, apply for an H1 premium processing ASAP. Okay?
Okay, I got it. Okay, thank you.
You're welcome. Okay. Yeah, that happens in my office too. This morning somebody asked me a question and I said, listen, until you are actually faced with a situation, don't ask me to write an essay, because the immigration law can be so complicated that the exceptions can kill the rule itself. So just find practical solutions. That's the right thing to do. If I was a college professor, I would love to write papers all day, but my job is to find solutions to practical solutions to problems, right? So this is a little bit of a difficult question from Preeti. She's a green card holder. She wants to get married to a Canadian permanent resident, and she wants to have the least amount of separation possible. And the only thing I can think of, Preeti, because you already have a re-entry permit approved. I read through the questions very briefly just before I started the call. So I know that you have a re-entry permit already approved. So that allows you to stay in Canada. Here's what you can do. You can start his green card now. Okay? Start his green card and move to Canada, stay with him. When it is time for his green card to come through, you should come back to the United States, because it is required that the person who gives the affidavit of support must be domiciled in the US at the time of the interview or in the process of being domiciled. So if I were you, I would start looking for a job or have a job by the time he's ready to come and go for the interview. Move, get an apartment. The consulate is going to ask, is Preeti living in USA? The answer is yes. Here is the apartment, and she's looking for a job, or she's already got a job, and that should take care of it. Okay. Now your questions were, how can he stay with me after the wedding? What are our options? What visa? So he can have an H1. If he gets an employer, he can also, if he wants to invest his money, he's not a Canadian citizen, right? No, he's not. So H1 is one option if he wants to stay here. Otherwise, you move to Canada if that is allowed under Canadian law. Do I have to apply for his green card immediately? There's no such requirement. You can wait until you get naturalization, but I'm not sure that's going to be of much advantage. I would just start the green card now. Why not? I have a re-entry permit. I was supposed to stay in India, so my plan changed. Will this re-entry permit count against my naturalization time period if I do not use it? No, it does not. Just having a re-entry permit does not affect your naturalization times or naturalization merits. It's when you actually use it and you leave the United States, that's when it affects your naturalization. Okay? *5 if you have a follow-up question, Preeti. *5. Press *5 on your phone. All right. Let's go on to the next question. I can never keep track of these guys. The Vinod says EB2 green card backlog and family-based green card spillover due to immigration executive order. So I don't know how long this is going to last. It looks like it's already reverted back to normal. The priority dates have gone back, right? So I don't know what the long-term effect is, but there are those two bills, one passed by the Senate and one by the House. This morning, Economic Times was asking me about what the effect is, and I said, it's so difficult to predict how things are going to go. So one version of the bill that would reduce your backlog has been signed by the Senate. One version has been signed by the House. When there is a difference in the two versions, they will typically have a bunch of people from both sides get together and try to iron out the differences, and that will then create a bill that contains the compromises made by the conference committee. They will then send it again for the approval of both chambers. Congress, Senate will approve it, House will approve it, and then it goes to Trump for signature. He's not going to sign. Hopefully by the time this all happens, he'll be out of the office anyway. Joe Biden, I think, will sign. So we'll see how this goes. I think it's a little early to predict. But the spillover, I think that is already over from what I could see. Okay. But don't be too sure. See, one thing I like about Mr. Biden is, remember, he's got decades upon decades experience in the Senate. So even though immigration reform as we want it may not be possible, but immigration reform is not out of the question, because they can still make a deal. And they really have to just make a deal in the Senate. In the House, we already have the majority, even though it slimmed down a little bit. So you never know. I think both sides realize that there has to be immigration reform in the United States. Now, if we have the Senate, I can expect that there'll be an immigration reform within 2021. But if we lose the Senate, the runoff in Georgia, if we don't have a majority in the Senate, then I think it could be dicey. I don't know how it's going to play out. But it's encouraging that the Senate has passed a version of the bill that gives me room for some hope that the plight of the extremely backlogged people will be addressed appropriately. And I do know that these factors of delay and the problems they cause for skilled workers are well known on the Hill. That's not something they don't know and understand. Everybody knows and understands that, okay? But I don't know how it's going to go. *5 if you have a follow-up question. *5. Okay, this one is from Dallas, Texas. Texas, go ahead, please. Yeah, Texas, go ahead.
This is Vinod to ask the question.
Yeah, call me Rajiv. Vinod, nobody calls me Mr. Khanna. Please just call me Rajiv. Okay?
Okay, Rajiv. Thanks for answering my question. So the context behind this question is that I've moved to Canada right now due to COVID. My company is allowing work from home.
Okay.
And I've been working remotely here for the last few weeks. So I'm kind of in a situation where I need to make a decision whether I should continue in Canada
Okay.
or come back to the US.
Okay.
If anything changes with the rules, that's why I asked this question. But I think you gave me a good answer. I'll just wait to know what happens with F386. Just a follow-up there is that, I wanted to know whether the bill F386 need to pass the Senate before Trump leaves the office, or will it get expired if it doesn't happen before January 3rd? So that information is kind of conflicting.
The bills, I don't believe they expire, although I have not been involved with the bill process for almost 9 years now. I used to be very much involved with everything on the Hill. In fact, I did help write the V visa um, statute, but I have not been involved for a long time. I don't think the bills expire, but they just kind of go into a dark hole because nobody really is paying any attention to them. So no, I don't think they're going to expire. I think by the time Mr. Biden gets sworn in, the bills would be very much alive. Okay?
Okay, thank you.
You're welcome. Okay, let's go on to, which one was this? Okay, no. Rakesh's next one. Transfer of H1B to a new employer and keep the green card going. Employer filed for 485 EB2 to EB3 downgrade. Got laid off in October. Oh, one day after. That's a little dicey. See, because unless something happened overnight, I always have a concern when somebody files a 485 and leaves within a few days. My concern then is, was that 485 meant to be for a job that was available indefinitely when you were planning to leave the next day or the employer was planning to fire you the next day? So I'm a little concerned about the merits of the 485. Has government uniformly come after these cases? No. Can they? Absolutely. I'm planning to transfer my H1B to a new employer and start working. Will this affect my I-485? Look, if I were you, I would get the H1B and I would actually start a new green card. I would not depend upon that 485. That is too dicey. I don't like it. If it were my brother or my friend, that's what I would do for them. Start a new green card, inherit the priority date of the old one. Let the 485 roll for now. It doesn't hurt, but be prepared to have your own green card in place in case that 485 gets knocked out. If it gets knocked out, you still have your own green card. Can I wait until I get my EAD instead of applying for an H1B? Oh, no. Get an H1B transfer done, please. I think you should protect yourself because I'm concerned about the merits of that 485. Okay. Star 5 if you have a follow-up question. Star 5. Yeah, that 485 looks really dicey to me. Okay, Rakesh is not here. Let's go on to the next one. This one is on salary reduction when changing jobs. Okay, so guys, this is a little complicated. Okay, I'm wondering if I should make it a frequently asked question, but I think we've dealt with this before. So essentially, the way this works is, first of all, remember, in the H1B process in this situation, you are dealing with two agencies. USCIS has its own rules. Department of Labor has its own rules. Sometimes you can be in compliance with labor but not be in compliance with USCIS and vice versa. What Department of Labor has said was, if there is a reduction in salary across the board and you get a reduction, as long as your reduction is not below the prevailing wage, we will accept it as a temporary problem. It's okay. USCIS has not said anything about it, but I don't think they will create a problem. So this is how we understand the situation to be today. Your prevailing wage was 57,000. I'm just rounding it down. 57,000. LCA salary was 65,000. But you continue to make, let's see, 59,000, which is 2,000 more than the prevailing wage. I don't believe you'll have a problem. So when you change your job, it should not be an issue. Okay. Nilesh, star 5 if you have a follow-up question. Star 5. All right. Let's go on to the next one. And this is EAD 2009, question number 10. What to do with the occupation column of G325A? Guys, I can't help you fill forms. Because most of the forms, they say if somebody helped you fill, they must sign. So I can't tell you how to fill forms, but I can make a general observation. So I am on EAD since 2012. I may get my green card in 3-4 months. You can work any number of jobs on GC EAD, correct? My question is, if one is an original permanent job which is mentioned in 485, 485J, and the rest are W-2 contracts, what should I mention in the occupational column? Well, when you say W-2 contracts, do you mean 1099? But in any case, my general rule is, I'm not going to tell you how to fill the form. My general rule is, if you have any doubts about what you should tell and what you should not tell, always attach a letter of explanation. Okay, so put a cover letter with your filing that explains, or put an attachment. You can say see attachment and just put an attachment and explain the whole situation. Don't take any chances. And I would give all the details, all the jobs. Don't keep anything back, including your permanent job, etc., etc. Beyond that, I can't really tell you because I can't help you fill the form. So you're always welcome to attach a letter or an attachment to that particular form explaining the situation. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Next one is Alok, and there's another one from Murthy. They are related questions, so the team put them together. Okay, please be a little bit quicker with your responses because I have to keep going back to the questions. So this one, somebody just raised their hand from area code 203. 203, where are you calling from?
Hey, I'm calling from Hartford, and my name is Suresh.
Okay.
The follow-up question, not raised by me, Kanaji, but I have a relevant question regarding 485 EAD 180 days rule. If I got laid off before the 180 days, can I use my EAD?
Oh yes, I'm actually coming to that. The next one,
Okay.
stay on the phone. I'll keep the line open.
Okay.
Because I think the next one is kind of like that. It says EB2 to EB3 downgrading and 180-day requirement. This is what Alok said. So he says, I've applied for EB2 to EB3 downgrade and concurrent I-485. I understand that I have to switch jobs using AC21 and then I have to wait for 180 days. Kind of your question. After I-485 was applied, also for the EB3 I-140 to be approved, I'm not clear about the 180-day requirement. The very next question is, I hold general manager title with SOC code this, wage of 120K, planning to start my own business. Can I sign my own? I-485J, I plan to do only after 180 days of both. Okay, so your question and these two questions are, I have to remember to mark this as a frequently asked question because this is important for you guys to understand. How does the 180-day period work? First of all, under American Competitiveness in the 21st Century Act, which is called AC21, an employee is allowed to change jobs to a same or similar position once their I-140 is approved and I-485 has been pending 180 days. Let's break this statement down. First, let us understand, when does that 180-day period begin? Let us say we filed an I-140 and a 485 today. After 100 days, I-140 got approved. When does the 180-day period begin for the 485 countdown? it already began when the I-140 was filed. So I just have to wait another 80 days. And then I'm fully covered by AC-21. So remember, the language of the law is I-140 is approved and 485 has been pending 180 days. It is not that 485 is pending 180 days after the I-140 approval. Is that clear or that's complicated? Did you get that?
Yeah, it's clear.
Okay,
Clear,
good.
but
Go away. I'm not done. Let me finish. I understand. I'm coming to the second part now. Now the second part is, do I have to hold that job which applied for me for 180 days? And the answer is no. The law only says, and so does the policy, that the I-485 remained pending for 180 days. So let's take a hypothetical. My I-140 was approved last year. My dates became current. I filed the 485. 10 days later, whatever happened, I had a falling out with my boss. I threw my coffee cup down. I said, I quit. I left. 10 days after filing 485. And let us say, now we are going to expand on this hypothetical. Let us say that after 180 days of my leaving, which is 190 days now, I got an interview. I go to the interview for my 485 and the USCIS officer says, hey, you didn't have that job for 180 days. You left right 10 days after the 485 was filed. And if you were our client, I would have told you to say, so what? I'm not required to hold the job for 180 days. The law says I-485 remained pending for 180 days. What I did in those 180 days, whether I stayed at home and watched cricket all day, or I worked 10 different jobs, I worked at a gas station part-time, none of that matters. What matters is three things. One, when I filed the 485, I had the intention to stay with this employer. 10 days later, I had a break up with the guy. That's not expected, right? So on the date I filed the 485, I did have the intention to stay. Second, I-485 remained pending for 180 days, which it did. Third, I have a job offer on Supplement J for a same or similar job. Even though I'm not working there right now, you have to give me my green card. As long as I intend to join that Supplement J job, if I'm already working there, great. If not, you still have to give me my green card as long as I'm willing to join and the employer is willing to give me the job. Okay, so that is the way the 180-day period works. I don't have to hold the job. I don't even have to hold any job. I can be even working as a taxi driver or an Uber driver if I want. As long as when asked, by the time I respond, 180 days have passed and I'm able to produce a job offer which is same or similar. Now ask your question.
Okay, the last statement answers me what you explained, that in the current scenario, before 180 days, if I got laid off, then I can join a new company based on my EAD.
Correct.
So how to explain? I think you explained the last line. So I have to hold a job when the interview comes. I have to explain that I have a same or similar job.
Exactly. And actually, if you're represented by counsel, don't try to give the explanation yourself. Let them draft a letter. Typically, what we do is, if we have to send in a new Supplement J, we send it a copy to the local office and a copy to the service center, just to make sure all bases are covered. Okay?
Okay, that answers my question.
And give you a third copy. And give you a third copy to take with you also. That here is the explanation. Okay.
So in that last question, but this would be like, if nothing happens, if I join a company in different company with the similar role, without a supplement J, and there is no interview, so no explanation, right? So is that UCS going to ask me a question in regards to that, or it's going to be hypothetical? They can ask, they cannot ask.
No, supplement J should be filed. If you have another job, you already got the job, file the supplement J. If you have not yet received a job or a job offer, then of course there's no supplement J.
Yeah, I received a job. I was laid off, and I have a job in my hand, but they don't want to do H1. So I have my EAD, so which is not past 180 days. So is that
yes? Once the 180 days are over, file the supplement J. Don't file it before the 180 days.
Okay.
Okay.
I think you answered it really.
Yeah. Supplement J must never be filed before 180 days.
After 180 days, I have to submit my supplement J.
Exactly.
Got it.
Okay.
Thank you.
You're welcome. Good luck.
Thank you, sir.
Okay. So back to the questions. I understand that I have to switch jobs. This is Alok. Switch jobs using AC21, then I have to wait 180 days after the 45 was applied and EB3 I-140 was approved. I'm not clear about the requirement. Do I need to wait 180 days? So I already clarified that. Okay. Next one is from Murthy. Can I file my own supplement J? And that's the major question. I have a hand up from 570. I'll get to you right in 1 minute. Let me finish Mr. Murthy or Ms. Murthy's question. So you can typically, this is where it gets even more complicated. Can you do a supplement J for yourself? And the answer is theoretically yes. Practically it is very complicated. I prefer that you don't do that. I'll tell you why. First of all, remember jobs have to be same or similar. So if you got your green card filed as a software engineer, and now you are going to be the CEO of your company, are the jobs same or similar? Well, maybe, maybe not. Let your lawyers make that decision. Second, there must be employer-employee relationship with your company. Somebody should be able to fire you. But if you are the boss in everything, it becomes a lot more complicated. Third, government can still say, they can't look at your taxes and all, but they can still say, we're not convinced this is a genuine employer. The company that started 3 days ago or 3 months ago. So there are these issues that I'm concerned about. And I prefer to avoid a situation where you are the chief and you are the Indian. You are the king and you are the peasant. Try to avoid that situation, even though it is technically possible. If you are going to do it, have a detailed discussion with a lawyer before undertaking that journey. Make sure you are protected. Okay. Let's go to area code 570. 570 is Pennsylvania, right? 1 second. 570. I'm sorry. I think I just.
Yes, Rajiv. Good afternoon.
You are from 570, right? Sir?
Right.
Okay. Go ahead. What is your question?
Same follow-up question with this. So say in my situation, if I file my 485 and then before 180 days, if my job is getting laid off, and then say I don't have a green card EAD, when I get a new job, right? So that new company HR might be asking, what is the work visa status right now I'm having? So what should I do in case like they are not willing to do my H1? You
can't work. You cannot work. You cannot work without an EAD or an H1B. So you have to then wait until the EAD comes through.
Oh, okay. All right.
Okay.
Thank you.
You're welcome. Okay, let's go to the next one. This one is area code 206. 206, where are you calling from?
Calling from Dallas. Actually, I'm the Murthy who writes the question.
Okay. Did you say Atlanta?
No, sir, Dallas.
Dallas. Okay. Yes, Murthy
Yes.
So I don't think that's a good idea, unless you have had a very detailed discussion with the lawyers about your business structure, employer-employee relationship, same or similar jobs, genuineness of the business, etc.
Yeah. Well, on that, a little bit more on the, since I hold the GM title, which is almost to be handling the entire operation,
Right.
which the starting the symbol will be done the same.
Right.
I thought it's not like handling.
Yeah, no, that part you have covered. Same or similar may be okay, but the other two are still problematic. First of all, employer-employee relationship. If you own majority stock, who can fire you? Okay.
Yeah.
I don't want to go beyond this because it's a long discussion. I don't have time for that right now, but I can cover the basic issues that you have.
Okay. All right.
Okay.
But even the salary part is not a concern.
No, salary part is the salary is a weird issue in AC-21.
Yeah.
What is the weirdness about the issue is this. There really is no law that requires you to have same or similar salary. Okay. What if your salary is $10,000 less or $10,000 more? Probably not an issue. The jobs have to be same or similar. But if there is a huge difference in the salary, 50% cut, it creates a doubt whether it is same or similar job. Okay. So the salary is not directly an issue, but the salary as an indicator of the underlying job, it could become an issue. Have your lawyers review that. Okay.
Okay. Thank you.
You're welcome. Good luck. And the last question in this series is from area code 615. 615, where are you calling from?
Hello, I'm calling from Pennsylvania.
Okay. Can you speak up a little bit? I can barely hear you, sir. Calling from Pennsylvania is what I heard.
Is it better?
Better, yes. Go ahead.
Yeah, is it better?
Yes.
Yeah, I'm Alok, the first question.
Right, Alok.
So the only question I have now after your explanation is, so let's say I switch after like 180 days after the 485 was applied, but it's not 180 days since the I-140 got approved. In that situation, can my previous employer revoke that I-140?
Well, the I-140 can be revoked if it was not pending for 180 days. Okay. Not approved for 180 days. They can revoke it, but because once I-140 is approved and 485 has been pending 180 days, even if they revoke the I-140, it doesn't hurt your 485 or your AC-21. Okay. So let me explain that a little further. Let us say that your I-140 and 485 was applied today. And let us say that your I-140 got approved after 10 days. Now after 170 days, you become solid as a rock because you are covered by AC-21. Your I-140 is approved and your 485 has been pending 180 days. Okay. Now there are two possibilities after that. Let us forget about this scenario. I-140 is approved again within 10 days. After 10 days, I-140 is approved. You will be very safe after 170 days. What if they revoke your I-140 before 180 days? I think then your green card is in trouble. What if they revoke on 181st day? Now they can revoke because your I-140 was approved less than 180 days ago. But they can't touch you because your 485 has been pending 180 days. So the bottom line is, I-140 revocation does not hurt you if it happens after 180 days of your 485 pendency. That's the bottom line. Okay?
So whenever I go for that interview, and at that point I will have the 485, but then the I-140 would have been...
It doesn't matter. It doesn't matter. Even if the I-140 is revoked, as long as it was done after 485 was pending 180 days, I do not think you will be affected. Okay. There's actually a case out of either New Jersey or New York. I think it's New Jersey. And the lady's name is Bhavani Mantena. The Bhavani Mantena's case, this was an issue. And the court said no. As long as your 485 has been pending 180 days, even if the I-140 is revoked, your rights are already yours to keep. Okay?
And the new employer obviously doesn't have to do anything with respect to the green card, right?
No. They just have to file your supplement J. Okay? Good luck, sir. All right, bye-bye. Okay, so now we are on question number, there's another one. Area code 203. Guys, you have to be a little considerate. I've got other questions to complete. Area code 203, calling from Connecticut, I guess. Go ahead.
Yeah, Kanaji, same thing to the topic which you just discussed.
Okay.
So revoked and withdrawn are two different things, right? For example,
look, the difference.
Hang on.
The difference between revoked and withdrawn is a semantic difference, but it can be, if it is in the sense that we are using it now, it can be a tremendously different thing. To withdraw means it is not yet approved. That's the way I understand it. So when the I-140 is not approved and it's withdrawn, you have nothing. But if the I-140 is approved and then they withdraw it, that's a revocation technically, right? Okay.
Clear.
Right. All right. Anything else?
Thank you, sir. That's it.
You're welcome. Good luck. Okay. So, guys, any other questions before I move on to the next one? Okay. I thought I was going to have more time than I did. I guess not. Okay. So, DV lottery people, I don't usually answer DV lottery questions because we don't do DV lotteries. But this is a relatively easy question to answer. If I win my green card lottery while I'm in the US for 4 months on a work visa, can I file my paperwork in USA itself? The answer is yes. Yes. So here is what you want to do. Google adjustment of status DV lottery. Google or whatever those search engines are. Just look for the phrases adjustment of status and DV lottery. You will get all the information you need. Okay. I'm not going to invite any follow-up question on this. So yeah, I would definitely, that's allowed. There's no doubt about that. Okay, question number 13. H1B extension and impact on green card processing when dates are current. I'm on GC EAD since 2012. Priority date is 2009. I may get to green card in 3 to 4 months after the last RFE. I know that you posted many times that we can work for 1, 2, 3 for any number of jobs on EAD. My question is if one is, didn't I already do this? Oh yeah, I think you have a follow-up question. Okay, I already answered this one. So there's a second question. If I-485 is linked with any issue with the H1B, I was never denied H1B. Extension was denied at one time. Okay, I remember this. So the way this works is, if you have a lot of issues about status, as long as you did not have unlawful presence, and that's your lawyers have to help you find that's a complicated issue. If you don't have unlawful presence, you leave USA, you go get your H1 visa and you come back and then you apply for a 485, beautiful, because that's like a dip in the holy river Ganges. All your sins are washed away. Okay? Except the sin of unlawful presence. So any status issues, unauthorized employment issues, none of that really counts anymore. So yes, section 245K as in kite, you can search that on the internet. Section 245K as in kite protects people in your situation. Okay. *5 if you have a follow-up question on this. Okay. And I think this is the last question. I may have time for 1 or 2 extra questions, but not a whole lot more. I-485 interviews in the year 2021. Expedite of a pending L1 based adjustment and mandamus. Would the green card processing be faster after January 2021? I have no way of knowing that. Can L1 AOS be expedited? No. But your AOS has been pending for 2 years. Yeah, I think you should file a mandamus. I don't think there's any harm in it. Talk with a lawyer and see if a mandamus is a good option for you. And normally, you see, litigations have a problem. So we filed 12 litigations against the government in the last few months. 11 were settled the moment we filed, within a few days. So we got everything wrapped up. Let's say it took us 3 weeks to prepare the lawsuit, another couple of weeks to get everybody served. Within a week or 10 days of that, so in a month and a half to 2 months from the day we started, we were able to get what we wanted. Okay. But there's another case that we have now pending for almost 4 months, and I know that's not going to settle because that's a lawsuit against the consulate. Those are a lot more difficult. Okay. So typically, case like yours, if it is settled, you could see something happen within 5, 6 weeks, 7 weeks of when you get started. I don't think there is any harm in it, but do check with your lawyers just to make sure there's nothing else that could complicate your situation. Okay? *5 if you have a follow-up question. *5. Okay, guys, let's wrap it up. I can try to answer a couple of questions more. Press *5 if you have any question. Press *5. So we'll do a lightning round because we have a lot of questions and I don't have time for, well, not too bad. We have 3. Not too bad. We can do 3. Let's see. Let's start with area code 832. 832, can you hear me? 832?
Yeah, I can hear you.
Where are you calling from, sir?
I'm calling from New Jersey.
Okay.
I work in New York.
Okay, so we are going to do a lightning round. Quick questions and quick answers. Go for it.
Sure, yeah. So I recently got my non-exempt H1B approval, like in the month of August.
Okay.
And I wanted to know, like, I had plans to travel to India, though, in the upcoming year, like Jan and maybe back in March. But I don't know, like, what you recommend in terms of whether I'll actually get a consulate appointment.
No, don't travel. Don't travel. I've got a guy stuck there for 9 months now. Don't travel. They are not issuing H1Bs except for those who are Dropbox eligible and except for emergency H1Bs. So don't travel. Not right now.
Okay, and I don't qualify for either, right?
Yeah, you don't.
Okay.
Okay.
Sure. Thank you.
Good luck. Area code 518. Where are you calling from?
Hi, I'm calling from New York, Rajeev.
Yes, ma'am.
Quick question. I live in USA. My I-130 was approved from my sibling.
G.
They send, after approval, they send it to National Visa Center.
ठीक.
But I'm still waiting. What is the difference? I don't need visa.
Okay,
Why
one second.
am I waiting for
One
this
second.
approval?
One second. You said you are in USA. What is your visa status in USA?
I'm dependent of my spouse who is on B1.
Okay.
It's a business visa.
Okay. Now,
Yeah.
I would want you to talk to a lawyer to make sure that you should be filing adjustment. It doesn't look like you should be, because typically what happens is if somebody is here on a tourist visa or a business visa, then they have given an indication to the government they are coming in temporarily. If they try to change to a green card status, government can consider that to be fraud, except under very limited circumstances. So I suggest you do a consultation with counsel, let them go over your case with you, and decide whether you should be doing adjustment of status. Because if somebody is in USA legally, and even though their case is going through NVC and all, they can circumvent all of that and just file 485 adjustment of status if their priority date is current. Okay?
Okay. No, I-130 was filed back in 2013 though.
Right. So yeah, that takes about 13 years. I don't think your dates are current.
They're not.
Yeah, so then there is nothing you can do. Just wait for the NVC. They will send some paperwork to your brother or your sister to file, including affidavit of support, etc. Eventually, the papers will be sent to the consulate. Okay?
And that should be coming in like a
About
month or so?
2026. Okay.
Oh.
Yeah, it's about
Okay.
13-year
All right,
process.
thank you so much.
You're welcome. Good luck.
Okay. Thank you.
Guys, don't do that. Once I said 3 questions, now 2 more people have raised their hands. I'll do my best. I don't know if I have that time. Okay, so area code 469. Go ahead. 469.
Hi. I'm calling from North Carolina.
Yes, sir.
I have a question on behalf of my sister. So the question is this. So my sister got married in India in the month of October. Spouse has a stamped H1B. They both are in India now. My sister applied for H4 appointment, regular and emergency appointment both.
Okay.
The emergency appointment just got denied. So she has to wait for a really long time for regular appointment.
Right.
She has a B2 visa. So can she enter in B2 visa citing the situation?
Okay.
And wait for H4
All right. Listen to me very carefully. I'm going to tell you what she should do. Do not deviate from this. And this call is being recorded, so you'll be able to listen to it again. First of all, there is no law that says she cannot. So tell her to clear customs or clear immigration in the Middle East, so that if they deny her entry, she can go back just 3 hours to India rather than going back from here. She should tell them that her husband is living in US. Okay? If they tell her, no, you should wait for your H4, go back, well, then that so be it. But if they let her come, then there is no problem. Okay? Got it?
Okay.
Good luck.
Yeah. So she has to come by a Middle East. Yeah.
I think that's a good idea. The clearance, I think, will happen in Abu Dhabi. Okay?
Yeah.
Good luck, sir.
Okay. Yeah, but thank you very much.
Oh, you're welcome. Okay. I think we are done here. Somebody had their hand up, then they put it down. Okay, very good, guys. I'll see you again in 2 weeks. Be well, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.